Losing a loved one is incredibly difficult. The last thing your family wants to face during a time of grief is a complex web of legal hurdles. Yet, a solid estate plan is one of the greatest gifts you can leave behind. Today, we will explore a crucial part of that planning, understanding the differences between revocable and irrevocable trusts. Choosing the right trust ensures your assets are handled exactly as you wish. Before we begin, remember that this video is for informational purposes only and is not legal advice. Let us dive into the world of trusts. Before comparing revocable and irrevocable options, what exactly is a trust? At its core, a trust is a legal arrangement where you, the grantor, transfer ownership of your assets. These assets are handed over to a trustee, a person or institution responsible for managing them. They do this for the ultimate advantage of a third party, called the beneficiary. The specific rules governing this relationship are outlined in a signed legal document. This very document determines if your trust is revocable or irrevocable. A revocable trust is exactly what it sounds like, flexible. As the creator or grantor, you hold the key. You maintain absolute control over the assets and can modify, alter, or completely dissolve the trust at any time during your life. One of its biggest advantages is avoiding probate. Instead of your family enduring long courthouse lines and costly legal fees, assets transfer smoothly and quickly to your beneficiaries. Plus, unlike a will, a trust remains completely private, keeping your family's financial details out of the public eye. Revocable trusts also offer crucial protection if you become unable to manage your own affairs. A successor trustee, chosen by you, can seamlessly step in to handle your finances, preventing a chaotic court-appointed guardianship. When it comes to taxes, a revocable trust is essentially an extension of yourself. You do not need a separate tax identification number. All income generated by the trust assets flows directly to your personal tax return, filed under your Social Security number. Because you retain control over the assets, the IRS still considers them yours. Everything in the revocable trust is included in your gross taxable estate. Transferring assets into this trust provides no step-up in basis during your lifetime. It is also crucial to understand that a revocable trust offers absolutely no protection from creditors. Because you can access the funds at any time, a court can force you to do exactly that to satisfy a judgment or pay off a credit card debt. Now let us turn to irrevocable trusts. Picture a heavy steel vault door locking shut. Once you place assets into an irrevocable trust, they are locked in. You lose direct control and cannot easily change the terms. But this loss of control provides ultimate security. Because you no longer legally own these assets, they act as a financial shield, protecting your wealth from lawsuits, aggressive creditors, and external threats. Irrevocable trusts are also incredibly effective for reducing estate taxes. By permanently moving assets out of your name, you lower your taxable estate. There are specialized types for specific goals: life insurance trusts, qualified personal residence trusts for your home, special needs trusts to care for loved ones with disabilities, and formidable asset protection trusts. Because irrevocable trusts are separate legal entities, they require their own tax identification numbers and must file annual tax returns via IRS Form 1041. Transferring assets into one is a permanent gift, which could trigger gift taxes if it exceeds your lifetime exemption. Another critical nuance is the loss of the step-up in basis. Assets in an irrevocable trust usually do not receive a stepped-up cost basis when you pass away. This means your beneficiaries could face significantly higher capital gains taxes upon selling those assets. While famous for creditor protection, exceptions exist. Transferring assets to avoid a known creditor can be ruled a fraudulent transfer by a judge, undoing the protection. Also, in a self-settled trust, where you are the beneficiary, your assets remain vulnerable to claims. Let us look at how these two trusts stack up side by side. Think of a revocable trust as an open lock or a document written in pencil. You retain total control to change terms or cancel it at any time. But an irrevocable trust is like a vault sealed with a heavy chain. Once you transfer assets into it, you surrender control and cannot easily alter the terms without beneficiary consent. Because you control a revocable trust, it offers no shield against creditors, and you remain responsible for all income and estate taxes. An irrevocable trust, however, acts as a sturdy brick wall. Since you no longer own the assets, they are protected from lawsuits and removed from your taxable estate, which reduces both your estate and income tax burdens. Despite these major differences in control, asset protection, and taxes, both trusts share two critical advantages. Both bypass the lengthy, expensive probate process entirely. And unlike a traditional will, which becomes public record, both trusts offer complete privacy, keeping your financial affairs strictly within the family. So, how do you choose the right path for your estate plan? The decision between a revocable and an irrevocable trust ultimately comes down to your personal goals and circumstances. If your main priorities are maintaining control, retaining the flexibility to adapt to life's changes, and saving your family the hassle of probate, a revocable trust is likely your best bet. On the other hand, if you are focused on minimizing substantial estate taxes, securing long-term care, or building an impenetrable shield around your assets to protect them from creditors or lawsuits, an irrevocable trust is the powerful tool you need. Let's answer some common questions. First, can you change the trustee of an irrevocable trust? While generally permanent, you can replace a trustee if the trust document includes specific replacement provisions or by court order. Second, what is a spendthrift clause? It is a provision that protects a beneficiary's inheritance. It legally stops outside creditors from reaching into the trust and seizing assets before they are actually distributed. Finally, what happens to your revocable trust when you die? It immediately becomes irrevocable. Your successor trustee then takes over, smoothly transferring the assets to your beneficiaries without going through probate. Navigating the complexities of trusts is not a journey you should take alone. Because estate laws vary by state and individual financial circumstances are unique, consulting a qualified estate planning attorney is indispensable. A professional can ensure you choose the right trust to protect your legacy and provide your loved ones with true peace of mind. Remember, this video is for informational purposes only. Always seek personalized legal advice to secure your future. Choosing between a revocable and irrevocable trust comes down to your primary goals. If you value flexibility and control, a revocable trust is likely your best option. But if your focus is on absolute asset protection and minimizing estate taxes, an irrevocable trust may be the way to go. Proper estate planning ensures your family's future is secure. Thank you so much for watching. If this video helped you understand your options, please like, subscribe, and drop a comment below. For more expert resources and guidance, visit funeralus.com. Take care and see you next time.